Welcome to The Explainer. Today, we're going to unlock the system that protects your fundamental rights and holds the UK government to account. Look, I know it can sound pretty complex, but stick with me, and you'll get the hang of the core ideas that empower all of us and keep the state in check. So, here's our plan for today. We're going to build this up in 5 clear steps. We'll start with where your rights even come from, then we'll look at how they're balanced, and we'll finish up with the powerful legal tool you have to actually challenge an official decision. All right, first things first, where do your rights actually come from? I mean, to really get how they work today, you've got to look back at the legal foundations that were laid over the last century or so. This timeline right here shows a massive shift. For nearly 50 years, if you felt the UK government had violated your rights, your only real option was a long, expensive trip to an international court in Strasbourg. But the Human Rights Act of 1998 completely changed the game. It finally brought rights home. And the real heart of this act, the engine room, is Section 6. It puts a direct legal duty on every single public body, we're talking everyone from your local council to the police, to respect your rights. And just like that, people had a way to hold them accountable, right here, in our own UK courts. Okay, so we know where the rights come from, but it's absolutely vital to understand they're not all the same. The best way to think of them is like a legal toolkit, right? You've got different tools for different jobs. Some are completely non-negotiable, while others are a lot more flexible. And this question gets right to the heart of the matter. The answer to the first one, an absolute hard no. But the second one, well, that's where it gets interesting, because the answer is it depends. And that distinction is central to how all of this works in the real world. So here's how that toolkit breaks down. On one end, you have absolute rights, like the freedom from torture. You just can't interfere with them, ever. Period. Then, in the middle, you have limited rights, like your right to liberty. Now, these can be restricted, but only in very specific, legally defined situations, like a lawful arrest. And finally, you have qualified rights. And this is where it gets tricky, because they require a balancing act. So, when it comes to those qualified rights, like your privacy or freedom of expression, how do courts actually do that balancing act? Well, they don't just guess. They use a very specific, structured legal framework called the proportionality test. This 4-part test is the crucial framework. It forces any public body to seriously justify its actions. First, is the goal even important enough to mess with a fundamental right? Is the method actually connected to that goal? Was it the least intrusive option available? And finally, when you weigh it all up, is it a fair balance? It's a really high bar to clear. And the Temple Bullock case is a really powerful, real-world example of this. You had a court that had to weigh a community's deeply held religious beliefs against the very serious risk of a widespread disease outbreak. By applying that 4-step proportionality test, the court ultimately decided that yes, protecting public health was a justified reason to interfere with that right. So we've got the foundation of rights, and we've got the test for balancing them. But we're still missing the mechanism, right? The legal lever you pull to challenge the state when you think it's acted unlawfully. That lever is called judicial review. Now, this is a super important distinction to get your head around. A judge in judicial review isn't there to decide if they agree with the final decision. Their job is simply to make sure the public body played by the rules and acted within its legal powers. It's a check on how a decision was made, not what it was. So think of it this way. If you believe a council's decision-making process was flawed, maybe they forgot to consult someone they should have, you seek judicial review. But if you think a lower court's verdict was just plain wrong on the facts, you appeal. They're 2 totally different legal paths. So how do the courts justify having this power? Well, the traditional answer is this idea called ultra vires, which is just Latin for beyond the powers. This frames the judges not as political enemies of the government, but as neutral referees. They're just enforcing the rulebook written by Parliament and making sure nobody on the field oversteps their authority. Okay, so you have the tool, judicial review, but on what specific grounds can you actually use it? Well, the courts have boiled it down to 3 classic pillars for a legal challenge. These 3 grounds right here are the absolute bedrock of modern administrative law. If you challenge a public body, your argument is almost definitely going to be built on one or maybe more of these. All right, first up, we have illegality. This one is all about authority. It's basically asking a simple question.
Did the public body actually have the legal power to do what it did, and did it use that power for the right reason? In short, did it stay in its lane?
Second is irrationality. And let me tell you, this is a much, much higher mountain to climb. You have to prove that the decision wasn't just wrong or misguided, but that it was so outrageous that no sensible person could possibly have made it. The bar is set ridiculously high on purpose to stop the courts from second-guessing every single political decision.
In number 3, we have procedural impropriety. This isn't about the final outcome, but all about the fairness of the process that got you there.
A huge part of this is the rule against bias. The famous Pinochet case showed dramatically that even the appearance of bias can be enough to get a decision completely thrown out. It's all about making sure that justice isn't just done, but is seen to be done.
So what's the result of all this? Well, this single number is incredibly telling. It's the number of times the UK lost a case in the European Court of Human Rights in a recent year. And that really low number strongly suggests that the Human Rights Act is actually working. It's letting our rights be protected effectively, right here at home.
And this is where we'll leave you. This entire system. It's designed to police the boundaries of power, not the wisdom of how that power gets used. It's about lawfulness, not popularity. And that question, where exactly we should draw the line between the courts and the politicians, is one of the most fundamental and ongoing debates in any democracy.